Okay, hi everyone. My name is Jim McCafferty. I'm an associate professor at Kennesaw State University. Welcome to CrimCon 2020. We're so glad that you're here. This is Thursday. We're on day 2 of CrimCon, and this is stream number 3. We have a roundtable here. I'll let the panelists introduce themselves here. But the name of the panel is Self-Preservation and Self-Defense in Prison. And for anybody that's attending this, if you look at the bottom of your screen, there is a box that says Q&A. If you click on that, you can ask any questions, and we're going to filter some questions through me and the other panelists later on. But as we're going through this panel, please take the time to ask some questions of our great panelists. But without further ado, I'm going to turn it over to our panelists here. Thank you.
Well, thank you for having us. We're delighted to be here. I'm Robert Johnson, a professor of justice law and criminology at American University. I'm very grateful, particularly to Brittany Ripper, who organized this panel. So we're going to just briefly introduce ourselves, and then I'll make a few introductory remarks about the subject, and then we'll move on to, I believe it's Hannah, Brittany, and then Cassandra. Is that right, Brittany? Is that the order?
Hannah, Cassie, and then I will go, talking about the law.
Right, very good. Okay, so Hannah, do you want to introduce yourself briefly?
Yes, hi, I'm Hannah Chesterton. I'm in my 3rd year of the Justice Law and Crim program at American University. So that's how I know these lovely people. And kind of my focus is like on law and society. And I'm going to be focusing today on the more philosophical question about self-preservation in prisons.
Perfect. And my name's Cassandra Moore. I recently graduated from American University and was a student of Robert's and met Hannah through some classes and then Brittany through Robert as well. I'm going to be specifically focusing on prison violence and why it exists in prison and kind of what it looks like from the prisoner's point of view and what drives someone to violence.
And I am Brittany Ripper. I am a 3rd-year PhD student at American University in the Justice Law and Criminology Department. And today I will be talking about the law of self-defense in prison when it comes to disciplinary hearings, and then also in the regular court system.
Well, thank you all. Just to give a little context, we want to start out by pointing out that prisons are thought of as organizations or settings of punishment. And that's certainly true, or corrections, but they are primarily living environments for the people in them. Inmates live in them, staff work in them, and the issue of self-defense and self-preservation is central, just as it is to people in any environment, including the free world. People want to be safe and secure in their lives. Remember that a prisoner lives in a cell or dormitory, which is an involuntary home. Perhaps you could think of the cell as an apartment, or if you're a lifer, as a condo, since you're going to be there for a very long time. Lifers have, or prisoners have a life in prison, or try to have a good life in prison. They live in what you could think of as a neighborhood on their cell block or tier. They have a kind of commute, as it were, to education or to work programs, to showers, to meals, to rehabilitation programs. They have places to mix as a congregate group called the yard. So there are many facets of the prison environment that have to be understood as living environments. The place is run by security staff, and it's an odd term in this context because almost no one feels secure in prison. Prisons are treacherous environments. They're dangerous places to live in, and they're dangerous places to work in. So this panel today is grappling with the key issue of how do you preserve your life and well-being in prison when you cannot rely on the staff to maintain your safety. You are ultimately, if violence erupts or problems develop, on your own. And how you manage those things involves a lot of different psychological adjustments and calls or line drawing as to how you can get through the day without getting hurt and without hurting other people. A lot of violence has an element of self-defense to it, And as we'll see, this is psychologically a very complicated issue. It's also complicated philosophically and legally and sociologically in terms of the prison environment. So I will turn first to Hannah Chesterton, who will talk about the philosophical issues that bear on this subject. Then we'll move on to Cassandra Moore, who will look at the sociological and social psychological issues. And then Brittany Ripper will look at the law. So Hannah, thank you.
Thanks so much. So just some questions at the outset would be, firstly, is self-defense is an instinctive reaction, but is it an inalienable, irrevocable right that is kind of fundamental to human beings and cannot be suspended even by the penal system? And also, much of the literature focuses on the collective context, such as war. How does that relate to the interpersonal context? So firstly, I think there's a strong argument that even if, and as we're going to be learning from the other panelists, even if personal self-defense is not always a lawful defense, it is a right, arguably. So looking at like Greco-Roman natural rights theory and law, the absolute ownership of property and of people by the family patriarch was well established. And so the patriarch was considered to have the right to engage in armed self-preservation to protect the people in his household and property. And so drawing on this argument, could argue that it's been well established for thousands of years, hundreds of years, that self-preservation should be considered to be a right that we've had for a very long time and something that is very natural to us. And then kind of the natural place to go from there is John Locke's inalienable rights, a political philosopher who accepted that we give our rights up to some extent as we enter into social and political contracts, but that there are certain rights that cannot be suspended, that can't be diminished. And self-preservation is part of this. It's a natural, self-evident right that's part of living and living a healthy life that is that has protected liberty. And similarly, looking at Thomas Paine, the idea that the government is obligated to protect our natural and civil rights, and these extend not just looking at life and liberty, but also to security and protection. And even if the government is supposed to uphold these rights, obviously that doesn't always happen. So arguably in this case that we're looking at today, prisoners aren't automatically extended this kind of sense that they have the right to preserve their life in any situation, whether it's in or out of prison. So Thomas Paine, looking at the violence of the colonials against the British, he believed that yes, it's important to have peace, but also in the pursuit of stable peace, that the colonials were justified in fighting against the British. And so just extrapolating his writings on the American Revolution, I think there's a strong argument there that just as the colonials were fighting on the basis of self-defense, that there's this natural right to protect your own life. And even when the government is not acting in a way that protects your life, that you should be able to preserve yourself. So as well as it being a right, there's also an argument that it's a moral duty, so that we have a moral duty to defend and preserve our life. So looking at natural law, this idea that people possess certain intrinsic rules and of right and wrong that aren't created by human law or by social norms, but these are general principles, and this includes the right to self-defense in the face of imminent threat. So I was looking at St. Thomas Aquinas, St. Augustine, and also the Catechism of the Catholic Church, this idea that legitimate self-defense is based on an imminent threat. And although St. Augustine disagreed, so believed that it was always, so he wrote that it's always wrong to kill a person, St. Thomas Aquinas argued and kind of interpreted Augustine's writings as meaning that you can never have the intention to kill someone, but if the intention is to preserve one's life, and the kind of corollary of that is that that person is harmed or that person dies, then you are justified because your intention is to preserve yourself. So even looking at it from a moral stance, there is a duty to self-preserve. And then finally, it's a social duty to preserve one's life in or outside of the prison setting. So looking at Hobbes and also John Rawls, this idea that as members of society, we enter into a social contract. And similarly to Locke, some rights we put aside for the benefit of the collective, but there are certain rights that we can never put aside. They're not conditional on anything, but we always possess them. And so as rational beings, Hobbes accepted that life is solitary, poor, nasty, brutish, and short. And I think in that, life is hard, and our natural tendency, and as rational beings, is to protect ourselves and to mitigate the nastiness of life and the brutishness of life. And so just in closing, looking at John Rawls, who is the most recent, so American political philosopher that I'm looking at, but most recent philosopher, this idea that justice is equated with fairness. So for us to live in a just society, for us to construct a just society, it needs to be fair. And for it to be fair, we are motivated to preserve our own lives so that we can participate in society. So looking at the kind of philosophical foundations of the legal system, I believe, and I think there's a strong argument for this, that it's not just a right, but that it is a moral and social duty, that it's not just an instinct, but it's something that should be protected in law, and it's not something that would be suspended just because you're in a prison setting.
Oh, thank you very much. That's a lot of food for thought for people who know the contours of daily life in prison, which involves a lot of anticipation of violence. Okay, next, Cassandra Moore, if you'll tell us about the sort of prison violence.
Thank you, Robert, and thank you, Hannah. I think understanding the philosophical background of violence and self-defense is really important when discussing prison violence in particular, especially when you talk about scenarios where an individual needs to defend themselves. Because as we've seen, prison violence is an interesting phenomenon for those studying the US carceral system. In an environment where individuals already lose a majority of their free will and face constant supervision, as Robert discussed, prison violence persists. We've seen gang violence, person-to-person violence, prison riots, and violence on behalf of guards in many portrayals throughout the media. However, most of these accounts fail to address the root cause of prison violence. And to begin to solve this issue, we have to ask what's an individual's motivation for committing acts of violence? And answering this question relates to the age-old nature versus nurture debate. Are incarcerated individuals predisposed to violence, or are they driven to acts of violence as a result of the prison environment? Similar to most things in the academic world, and based on my findings, the answer seems to be both and a lot more. What causes prison violence can be explained by examining the prison administration's ability to control the type of offenders, the prison code, gangs, overcrowding, the mental and emotional state of the incarcerated individual, and so on. A majority of my research and focus on case studies and literature reviews of prison violence, and throughout my research, it became increasingly clear and evident that an individual's mental and emotional state coupled with the prison administration abilities and capacity to control correlates the most to why prison violence exists. The article Inmate Society in the Era of Mass Incarceration by Derek Krieger and Candace Crutchmit drew correlations to the demeanor of incarcerated individuals and overcrowding in prison to the rates of violence. They noted specifically and prisons that house a greater portion of younger or more aggressive inmates, crowding increased levels of misconduct. So essentially, the administration's capacity to control incarcerated individuals and the number of violent offenders in a particular prison seems to directly relate to levels of prison violence. Additionally, the article Violent Victimization Among State Prison Incarcerated Individuals, published in Violence and Victims, suggested that according to the administrative control theory, studies show that incarcerated individuals are less inclined to use violence or react in volatile ways in situations and institutions where there are higher levels of institutional control. Therefore, essentially, if the staff is able to protect the individual, there would be no need for violence. But if the administration has failed in their duty to protect incarcerated individuals, sometimes they have to react in preemptive acts of violence in order to survive. And as previously mentioned, an individual's mental and emotional state in prison is shown to have significant effect on their predilection to violence. The article Interpersonal Violence and Social Order in Prisons by Anthony Bottoms noted a number of prisoners suggested to a researcher that getting tough often requires more than just tough talk, meaning the ways in which people portray themselves in prison alone won't guarantee their protection or their survival. And in some circumstances, incarcerated individuals appear to adopt a kill or be killed mentality when feeling threatened. Prison violence essentially is a means of self-protection when there are no other means. Additionally, a chapter devoted to prison violence in Hard Time by Dr. Robert Johnson, who we speak here with today, noted that the code dictates individuals maintain a tough or violent demeanor in order to secure respect from others, and when and if disrespected, they must respond forcefully. The nature of prison itself seems to create a powder keg of violence within the prison. With little means of coping, incarcerated individuals will find themselves strained, stressed, in emotional distress, and therefore grasping at ways to survive. It's common knowledge that there's little mental health resources and adequate mental health resources across most prisons in the US. Therefore, individuals are individually responsible for developing coping mechanisms in order to maintain their physical and emotional well-being, which can explain these acts of violence and essentially justify anyone's predilection to violence when feeling incredibly stressed. Lastly, a piece titled The Prisoner's Dilemma, How Male Prisoners Experience and Respond to Penal Threat While Incarcerated by Catherine Meyer and Rosemary Riccadelli, specifically noted that using violence or fighting back is the most effective strategy to demonstrate one's physical prowess or strength, specifically in prison. In this sense, aggressive or violent actions are essentially a necessary tool for survival in prison, especially when individuals are given no other means to guarantee such. In any other circumstance beyond the prison walls, we would likely refer to this form of violence as I've described, and as Hannah discussed, as self-defense. However, as will be explained through Brittany's presentation, incarcerated individuals have no right to such. Though the right to self-defense and self-preservation is, I would argue, and most of us would argue, that is a right that's innate. It cannot be restricted regardless of one's circumstance and regardless if an individual is in prison. So next I'm going to throw it to Brittany to discuss the legal ramifications and what it looks like on the legal side of self-defense in prison. Thank you.
Thank you, Cassie.
Thank you. So I want to begin by talking about the case Roe v. DeBruyne, which is really the first case that held that people in prison do not have a constitutional right to self-defense. Now, this was a case back in 1994. It's a federal court case from the Seventh Circuit. And starting out with the facts of the case. So Roe had a new neighbor who was housed right beside of his cell. So the cell beside him had a new individual in it. He was concerned about his safety because this individual had passed him a note saying that, you have been sexually enticing me. We need to have a sexual encounter. If not, there's going to be violence and maybe even death. So the next day, after this new individual passed Roe this note, he actually attacked Roe. And in response to this attack, Roe hit this individual on the head with a pot. So at this point, another incarcerated individual was able to come into the cell and break up that altercation. But everybody involved in that altercation, the aggressor, Roe, and the person involved in breaking up the fight were charged with battery in the prison disciplinary system. Roe was able to put forth this evidence saying, I fought back in self defense. I should not be found responsible for this disciplinary infraction of battery. And the disciplinary board said, it doesn't matter. We have a rule against no fighting. You participated in fighting. Therefore, you are responsible for this disciplinary infraction, and we can hand you down a punishment. In Roe's case, they sentenced him to a year of administrative segregation, which is a nice euphemism for solitary confinement. But due to Roe's circumstances, they considered his defense of self-defense mitigating. So they still found him responsible for the act of battery, but in his case, it's on his record that he committed a battery, but the disciplinary board decided to suspend that sentence of solitary confinement for a year. But even having that infraction on your record can be detrimental for incarcerated individuals. And this is especially true when they're coming up for parole. If a parole board is looking at these disciplinary infractions and sees that someone has an assault on their record, that's not going to look good when that person's trying to get released. And in Roe's case, it's on his record that he was responsible for an assault, when he was just defending his own life. So Roe appealed his case, and it got up all the way to the Seventh Circuit Court of Appeals. And what the Seventh Circuit held was interesting. So first, they held that there is no constitutional right to self-defense for anybody. And then they said, second, even if there were a constitutional right to self-defense, it's okay for the government to take that away from incarcerated individuals as long as taking away that right contributes to a legitimate penological interest. So helps in the administration of the prison, helps carry out the punishment. And what the court said was, that's exactly what this disciplinary board did. There is a legitimate goal in curbing violence in prison, and by banning any violence, even violence that is come about to by self-defense, they are creating order and safety in the prison environment. We know that that's not true. One, because of our natural instinct to fight back when our life is threatened. And it doesn't create a safer prison environment, because then these individuals who are preying on other people are able to go about the prison environment doing this without recourse. And so one thing I wanted to mention when it comes to court cases, so this is a federal court case in one federal circuit. That doesn't mean that it's binding on other federal circuits in the US, but other circuits have latched on to this case from 1994 that stands for the proposition that people in prison have no constitutional right to self-defense. So for the past 25 years, many court opinions, and there are 131 court opinions that cite this DeBruyne case back from 1994, and are saying that no, we see your case. There is, great evidence, or at least some evidence, that you committed this act of violence and self-defense. But this 1994 case from the Seventh Circuit says no constitutional right. You're still getting punished for it. And there's a recent case from 2016 where the individual got a new cellmate, and within 15 minutes of getting this new cellmate, the cellmate punched him in the face. And this individual put the guy who punched him in a chokehold and was screaming to correctional staff saying, "I'm doing this in self-defense. He attacked me. I'm doing this in self-defense. He attacked me." And this individual still was found guilty or responsible of assaulting the person who punched him and got a reduction of it in his good time credits. So in the federal system and in some state systems, you can get out a little bit early for good behavior, a reduction in these good time credits, and was also subjected to a year of solitary confinement. So even though we think that it's okay to infringe on some rights when someone's incarcerated, infringing on these rights does have dire consequences, namely when it comes to the reduction of good time credits. That's very important for individuals who were incarcerated. That's what they're latching onto in their daily lives. And also the fact that even if they don't get a punishment of solitary confinement, having that disciplinary infraction on their record can have serious consequences when they're up before the parole board. And I also wanted to mention there are some courts that do reject Roe v. DeBruin, and one of them is the New Jersey State Court. So the New Jersey State Court said this, the logic of the Seventh Circuit does not make sense to us. Self-defense is a right, and we agree with the dissent. The dissenting judge in Roe v. DeBruin thought that if self-defense was done away with in prisons, the vulnerable and the weak would not be protected. And the New Jersey court agreed with Judge Ripple. And what they did was actually implement an administrative code that said, yes, people in prison they can put forth the defense of self-defense if they're up before a disciplinary hearing, but the burden is on them. And that's fine, because that's how it is in normal court cases. If somebody was charged with assault or murder in just a regular criminal court, self-defense is an affirmative defense, meaning they can't just say, oh, I did it in self-defense. They have to prove it. And next, I want to get to the issue of why this is important. The first reason why this is important is because of the safety of incarcerated individuals. So we're putting them in these hopeless, difficult environments, but we're not affording them a basic, I would say, inalienable right of self-defense. So we're putting them in a place where they can be preyed upon, but oftentimes they're not protected. Second, the punishment of solitary confinement can have detrimental effects on one's life years after prison. And so the effects that this does to your brain, this punishment should not be taken lightly. Like I mentioned before, disciplinary infractions can be detrimental to parole decisions when someone's coming up before a parole board. And I think most importantly, if individuals do not think they're being treated fairly in prison, this goes to the notion of procedural justice. Why are they going to decide to follow the rules after, even when they're trying to do the right thing, they get punished for it? Why are they going to try to follow the rules in society once they get released, when the government will just punish them for no reason, it would seem to them? And one other thing I wanted to mention is that we need more research on the disciplinary process in prison, because there hasn't been a lot of research since the 1980s. Anne-Marie Rocheleau did publish an article in Qualitative Criminology a few months ago where she interviewed incarcerated individuals in Rhode Island and also interviewed the staff about how fair they thought the disciplinary process was. The incarcerated individuals didn't think it was fair. Over half of the staff members didn't think it was fair. So this is an area that I think a lot of people just don't know about, that people who are subjected to prison disciplinary hearings can't put forth that right to self-defense. But I think it's an area that we can fix. I think that if we implement certain procedures in prisons to make them more orderly and safe, I think that could be helpful. I think states can implement their own statutes like New Jersey did, affirmatively stating in their laws that people in prison can put forth that right to self-defense. And I think most importantly, we need research on this area.
Well, thank you for those thoughts. It reminds me, my research in prison goes back to the early 70s with Hans Took, and one of the first officers I interviewed at Auburn said to me, I'm a security officer, which means I should make this environment secure. If inmates arm themselves or get involved in preemptive violence, I have failed. That might be a better attitude for the staff to take. to argue that their job is to promote security. Hannah, in your presentation, fairness was a key issue, right, in terms of the philosophical issues?
Yeah, absolutely. Yeah, several.
Yeah.
Yeah, in several of the writings.
The reason I say that is I know that Alison Liebling and others have studied environmental, the ecology of prisons, have determined that fairness is a central demand or desire of inmates. And as Brittany has pointed out, it's very central to people's adjustment to feel that they are in a setting where they're treated fairly and ideally with respect. So very nice to bring that the latest research in on disciplinary boards in prison. That is the justice system inside the prison. And it is limited in ways that probably feed into some of the perceptions that Cassie talked about. That makes sense to me, certainly. As you all know, I've done a couple of cases where I've been an expert on self-defense and homicide cases. And basically what you're trying to tell the jury is this person came to reasonable beliefs about his safety, and sort of complicating the philosophical issues, they recognize that in this setting, people have long memories, so that when they get involved in preemptive violence, there's a certain appeal toward lethal preemptive violence, because if you're not successful in killing the person that is in fact a serious threat to you, he will come back into your life almost inevitably. So we might have to ask ourselves, if the prisons are Hobbesian, at what point can you stop at simply neutralizing the incident that you were involved in and not worry about future consequences? So are we ready to open up to questions from the
I think we
audience?
are.
Great. Thank you for all your thoughts. Thank you, Jim.
Thank you. I thought that was very interesting. I've never really thought too much about self-protection in a prison setting, so I found that very enlightening. We don't have any questions yet, but I have a question, if you don't mind.
Sure.
And my question, and I'll just say one more time, if you are an attendee and would like to ask a question, there's a Q&A box at the bottom where you can type something in and we'll read it and ask the panelists. I'm just wondering if the reasonableness of self-protection changes whether or not somebody is protecting themselves from another prisoner versus a prison official, like a guard or correctional officer. Is there a different calculus that's used, whether it be philosophically or from the court when they're trying to make determinations about that, those self-protection actions?
Brittany, you want to handle that, or would you like me to start?
You can start, and I can, based on your experience, and I can add to that.
I would say that officers have to draw some similar lines about their own safety. So I was involved once in a case with Rikers Island, a very sort of a hotbed of officer violence. But one of the issues that came up was that different officers had different thresholds for when they thought they were going to lose control of a situation. And then they had to act with force before they did, in fact, lose control of the situation. Since officers, especially in a tier or cell block or yard, cannot lose control of the situation without jeopardizing their lives and the safety of the prison. So anybody in a situation where there's a threat and a judgment about when to use force has a similar kind of calculus. And I think we are certainly more forgiving with officers, but they too are constrained with cultural factors of the ones that Cassie mentioned, and also logistical questions, because almost all these settings are grossly overcrowded and understaffed. So that puts the staff in a situation where their definition of the need for force may seem very arbitrary to outside observers who are not as in touch with the ebb and flow of violence in the prison. Brittany, you want to elaborate on that or discuss something different?
Yeah, so for the person who's responding in self-defense, what's key when we're looking at this defense is reasonableness and imminence. So, and that can really vary from person to person based on, their past experiences and their location. So it would be the same reasonableness concern, but whether or not the court or the disciplinary board is going to view that could definitely differ based on whether or not the victim of that battery is an incarcerated person or a correctional officer. And oftentimes, if somebody is trying to challenge a use of force or treatment by assaultive treatment by a correctional officer, they'll try to make an Eighth Amendment claim. Well, it's actually hard to do that when it comes to correctional officers because there's a standard called deliberate indifference. So the officers had to act in such regard that they almost purposefully did something wrong to an individual, and that can be extremely hard to prove. And I do think that when it comes to correctional officers, when we're thinking about the disciplinary boards in prison, those individuals might be more likely to listen to the account of the correctional officers when it comes to their account of an altercation versus the incarcerated individual.
Now, I am not a lawyer, and this may seem like a silly question, but do officers and inmates have an equal right to be protected in the prison environment?
That is something that I would have to look into exactly when it comes to like the constitutional law on that.
Mhm. That's I ask that because if you work with officers, and I certainly sympathize, that if violence breaks out, they will retreat and wait for backup because well, that's policy for one thing, but also because historically there have been situations where they've been hurt badly or even killed. So that's a judgment that they make following policy that clearly puts the lives of officers at a higher value of protection than the lives of inmates. Now, this may seem self-evident inside the prison, but outside, if you go to prison and you say, well, people go to prison and the environment there the people who rule the environment have a primary obligation to provide secure setting, like any person in authority, then they should be technically viewed as of equal weight and are reflected in policy, I would think.
Yeah, I know, and I still have so much to dig in when it comes to the cases on this issue, but I know that in at least some prisons, there is this policy where the correctional officers, they do, as we know, need to protect individuals, but risking their lives to do so, to break up a fight, is not always required because it needs to be essentially, pretty easy for them to break up a fight in order for them to get involved, because they could be put in harm's way. So in that certain instance, I guess they would have more protection than an individual who is stuck in that altercation at the moment.
Well, if you read oh, I'm sorry, go ahead, Jim.
I was going to say there is a question if you'd like to. There's a question.
Oh, yes.
Yes.
Of course.
So Linda asked, in your research, have you come across any gender differences in self-defense responses in prisons?
I have only looked at self-responses in men's prisons. Certainly women have an equal desire to be safe. I don't know how violence figures into that safety, whether it is as salient as it would be in men's prisons. I would think not, but Brittany, do you or any of us have looked at that? That's an important area.
Yeah, so I actually, all the literature I've examined has actually just talked about men, and which is most criminological literature. A lot of the violence in prison, it's going to depend on the risk level. That's just a general statement. So if you're at a federal prison camp versus a maximum security prison, that might be one differential. And this is just anecdotal, but talking to a previously incarcerated female about her experience, she did note that in her particular prison, it wasn't a constant fear of violence like we often have in the men's prison, but there were a few interpersonal conflicts, and they usually had to do with like romantic relationships.
Did they result
in violence? Yes.
Yeah, Cassie, in your literature, you did a pretty thorough review. It's all men, isn't it, that we surfaced?
Yeah, all of my research is based on men's prisons, but kind of going off of Hannah's point too, what we've talked about a little bit, I think the need, regardless of gender, still exists for the right to self-defense. I think the psychological state of the individual in prison is the same, regardless of whether it's women's or male's prison. I think there still exists this need to protect oneself because in prison, as I saw in my studies, there's an intense amount of stress and distress on the individual's mind. Prison is feels like an inherently dangerous place, even though most prisons are not inherently violent. There are instances of individual and institutional violence, but those exist regardless of gender. And therefore, I think the need and want for self-protection is the same.
I wonder if we had a scale of self-defense options, what people would trot out as examples of things they did in self-defense. And if we did, I would bet men would turn to violence quicker than women. And there might be other adjustment tactics that serve self-defense but are not violent. So that would be something we could think about. I know Pollock and there's a very good book on women's search for safety in prison. And for some reason, I'm blanking on some of the details right now, but that's where I would go after this conversation and take a look at that book.
There's something that I forgot to mention in my presentation that I think is an interesting fact. So since our presentation was primarily talking about the disciplinary hearings, that's why our main point of this is to show that there's no constitutional right for incarcerated individuals to put forth this defense when they're before the disciplinary board. But in a lot of the cases I looked at, when an assault becomes lethal and an incarcerated person is accused of a murder, that's taken up by the normal criminal legal system. And so when they are not going to be before the disciplinary board, when they're going to be before a judge and or jury, that's when they're afforded the right to self-defense, when they're taken into a normal court situation. So it has to take a lethal act of violence for them to be able to get their right to self-defense.
That's right.
That's
The case,
interesting.
I'm sorry, Hannah, go ahead.
Oh, no, I was just going to say that's interesting because I think that particularly the moral dilemma, or at least philosophically, that's where it's more contentious, right? So like to take someone else's life is more contentious, or even with, and I know that you mentioned this, Rob, when, it might be easy to say when you don't intend to take someone's life, but you just do because you're in your own act of self-preservation. But actually, if you do intend to take their life because you know that if they survive, you're actually in a greater risk of being a victim of violence. I think it's interesting that the defense of self-defense would be like applicable when there's a higher threshold, right? When there's been more of when the act that you've committed is actually more morally contentious. That's the only opportunity that you have to protect yourself in the court and say, well, actually, I acted to preempt my own death. So I think in a way the philosophy doesn't really line up with that very well, because I think philosophically it's easier to justify when it doesn't end in someone's life being taken, if that makes sense.
Oh, it does. I think the philosophical context has to take into account the prison context, and the prison context is very much Hobbesian, and even maybe more than Hobbes had in mind, or can be anyway. I wonder if a person on the way to the electric chair or the lethal gurney has a right to self-preservation. Only a tiny number of people ever fight back. Most people are quite defeated by that point, but occasionally people struggle. And if you have a right to self-defense and your life is being taken, even lawfully, I wonder if you have a right to defend yourself. That's pushing it a little, of course.
Yeah, but in a way, there is an official revocation of your right to self-preservation, even if that's not articulated through the death sentence. I guess implicit to the sentence of death is that you have your right to self-preservation taken away. Okay. So maybe in a way there is that step, whereas when you are sentenced to, a prison term, that's not necessarily, I wouldn't understand that to be implicit, that the court is saying, we suspend your right to self-preservation, whereas a death sentence, it's almost, from my opinion, in my opinion, it's almost kind of part of the whole process that you no longer have a right to prevent your own death.
I agree with you.
So apparently it's revocable. Brittany, you were saying something? Sorry.
Oh, I was going to echo what Hannah said. Exactly. That
Okay.
the court is telling you, you have no life. This is a lawful order. And so if you have no life and your life can be extinguished, I think that automatically just takes away your right to defend yourself if you were on the way to the electric chair or the gurney.
Yeah.
So the legal system can suspend a natural right if it is a natural right.
Yeah, and maybe the logic there is because what you have committed was not justified by self-defense. You took, and because usually, I mean, well, nowadays it would be because you took a life. So because you took a life and you did not do that in self-defense, you've met this kind of moral threshold where just in taking a life, you then deserve to have your own life taken. Maybe that's the moral logic behind that.
Okay.
And I think
Well, you've also got life without sorry, Cassie, go ahead.
Yeah, I think going off that's like an important point too. When you talk about when someone enters prison, obviously they give up certain rights. They give up their right to their own free time. They have no control over their own food, all that. And you could argue when they take a life, they then give up the right to protect their own. But before that, I think there's no scenario where an individual gives up their right to self-defense. Because they haven't done anything to justify that. Yes, they've broken a law and have entered prison, have been forced to enter prison, but when they enter, they still don't give up their innate right to self-defense. I think that's a moral argument that I think there is no way to justify someone can lose their right to self-defense because everyone has the right to self-preservation in any circumstance.
Well, that's why I was wondering about on the way to the electric chair. So, but now life without parole is considered a death sentence, or you're sentenced to die in prison. That's what life without parole means. So if you're sentenced to die in prison, has one's life and therefore self-preservation rights been suspended?
I mean, I guess well, if you are a lifer who is claiming self-defense before the disciplinary board, I guess it has, depending on what institution you're in. So if you are in a federal institution, we know that the board of the federal prison system has a blanket rule against violence, including self-defense. And then beyond that, it'll just depend on what state facility you're in. If you're in a place like New Jersey, where they say you can go ahead and put forth the defense of self-defense if you're before a disciplinary board, that's okay. But if you're in a state that is not allowing that, then essentially you do lose your legal right to self-defense. And one other thing I wanted to mention, I think that,
I'm sorry, I don't mean to interrupt, but we have about 2 minutes left if people want to make some closing remarks.
Well, Brittany, you make those remarks, then we'll just say that we were happy to be here, which is true.
Good. Yeah, so I think we all assume that we have a right to self-defense. It's not something we really have to think about, where is this in a law? Where in the court opinions does it say that we have a right to self-defense? I think we all assume that we do. And I think that was part of the issue in Roe v. DeBruyn, where they said, hey, there's actually no constitutional right to self-defense. Because I think courts up until that point didn't really have to grapple with that, because it's something that we all, think we have as a natural right and an inalienable right. And I would argue that we do have a fundamental constitutional right to self-defense, that this right should be afforded to people who are in institutions.
Fantastic. I say we all go to New Jersey and take a look at their prisons now that they're claiming the right to self-defense in the New Jersey prison. So, yeah. Well, thank you all for being here. And Jim, thank you for moderating. We were very happy to be here.
I'm very happy to have had you here and to sit and listen to this today. I just want to thank our panelists. I would like to thank everybody that attended today. This is only day 2 of CrimCon ever, and this just happens to be, I didn't tell the panelists beforehand, this just happens to be the first ever roundtable at CrimCon. So yesterday was filled with traditional panels, and I think that this went really well, and I really enjoyed learning from all of you and listening to this. A couple of housekeeping notes before we say goodbye. The videos from this will be posted to YouTube, I believe, sometime by the end of the year. That's our plan, at least. And then I'm going to be ending this stream for 5 minutes and taking a break. And then I'll come back if you want to attend the next panel. I'll be back broadcasting again at the top of the hour at 10 o'clock. So thank you everyone for coming. I appreciate it. And please be safe and healthy. And I will talk to you soon.
You too. Thank you all, guys.
Yeah.
Good to see you.
Thank you. Bye-bye.